Hi, my name is Reen. Sounds like green. I'm a Minnesota licensed realtor helping families get through probate with more money and less stress. Today, I'm joined by attorney Boë Bowen from the Bowen Law Firm in Houston, Texas. Bo, welcome to the show. Please tell us a little bit about yourself and why you chose this line of work.
Uh, my name is Boë Bowen, and I'm the main manager that runs the Bowen Law Firm. I've wanted to be an attorney since I was knee high to a duck. I mean, oddly enough, I actually went trick or treating in middle school where I wore my Sunday's best. I took a backgammon case. There were no briefcases in our house, and I went trick or treating. I pretended to be an attorney. It's what I've always wanted to do.
Oh, that's fantastic. That's fantastic. And then just to go a step further, what drew you into probate work as an attorney? I know not all attorneys have an affinity for estate planning and probate. How did you land in that line of work?
When I created my own firm, I wanted a firm that was based to help families, and you really can't help them unless you deal with death. And also, more importantly, planning for it to make it easier on the people that are left behind. But you also do family law and personal injury and things like that. But like I said, it's all more family centered, and you really can't help families without dealing with this part of it. And there's right and wrong ways. I'm good at getting families to work together and keep the peace, and that's always important when people are suffering like they are through losing a loved one.
Absolutely. And I know Texas is a big state. My mom used to live in Texas. Do you focus in just the Houston area, or do you do cases all around Texas?
All over Texas. I even finished up a trial in McAllen earlier this year.
Mm,
So people want me to come and fight, we will go and do it, but we do mainly have cases in Harris, Montgomery, Fort Bend, Waller, Houston and surrounding communities.
excellent. And Bo, we wanted to talk a little bit about probate today. And I know in your firm and the work that you do some estate planning to help people avoid probate. You also help families through probate. Could you just talk a little bit about probate and the timeline and some of the issues you see with families going through probate?
Yeah, sure. Well, when it comes to probate, it actually isn't that bad as long as the person did a little bit of work beforehand. And we're talking about an estate plan. And this is extremely important for everybody once you're over the age of 18 or if you're on your own, right?
Hmm.
A lot of people think just a will. There's a lot of things you need more than just a will to help you get ready for this because a lot of people are in the hospital and they can't answer for themselves. And instead of making it easier on their loved ones, they now have to go get a guardianship versus having a document that says, I wanted these people to speak for me when I couldn't.
Hmm.
I know it's difficult to think about those things, but we have to. It's the only thing we're guaranteed is death and taxes. And so we help
Yes.
with preparation for the death part. And everyone acts like probate is a huge ordeal. And they're right, it can be if you didn't prepare. And if you simply get a will, at least in Harris County, you're looking at typically 6 to 9 months, worst case,
Hmm.
9 to 12. All right, assuming it's an independent administration, which you're going to get those things if you do and take the time to do a will.
Right.
And in fact, of all the documents, not even the will, I think the most important document would be a directive to physicians, or what other states are calling a living will. I've
Hmm.
seen more fights and schisms in families that didn't need to happen because of the lack of that document. They had the will, but they didn't have that. I, such an easy thing to do. And a lot of people don't know what I'm talking about. I'm sure you do when I'm talking about a directive to physicians or a living will.
Hmm.
And this is the document, it's also known as an advance directive, but it's a legal document that will allow that person to communicate their medical treatment preferences. So in Texas, documents used to help ensure that a person's wishes are respected if they're unable to communicate due to some kind of illness or injury. And what it does, it takes that burden off your wife, your daughter, your sons. I can promise you, you may say, this is when it's time for treatment. I don't want it anymore. But your son may not feel that way. Your daughter may not. And then he's created this huge problem when they need each other more than ever now, and they're not going to be there.
Absolutely. Bo, one of the questions I have in Texas, do you see families, excuse me, in Texas, do you see families who confuse the authority granted with the living will versus authority that's granted with power of attorney?
Yes, sir. Now, if they come through us, a lot of times we eliminate those issues. It's good to have one king. When you start breaking up powers and such, you're going to have fights and people start getting confused about who does what. The only time I thought it was a good idea is if you have someone who is medically trained. Then, of course, let them handle the medical power of attorney, right? But they don't have to do the durable statutory power of attorney. But it does make things easier when you have the one person who can do it all.
Absolutely. And as a real estate agent, one of the other things that I run into, and as an attorney, I'm guessing you do too, sometimes I will work with families who have a will, but they have not filed for probate. And in the state of Minnesota, they have to file probate to execute the will. And so they'll come to me, and they're maybe it's been a year or two, and they're ready to sell their house, and they say, "Yep, I'm the executor, and I have a will." And I ask them for their letters, and they say, "Yeah, what letters? Well, we don't know what you're talking about." Do you see that situation with families as well?
I do, and hopefully they get to me before 2 years because the rules slightly change in Texas, get significantly more difficult after that. It is ideal to always probate within 2 years of the death. And
Mm-hmm.
whether they know or not, visit with an attorney. You may not need to. Just because they have a will doesn't mean they didn't do TODs, which are transfer on death deeds, or a ladybird deed, or some form of a transfer upon death. Because probate matters when you need wills. You don't always need wills, right? You
Mm-hmm.
need them, but they don't always need them definitely to go through probate because you could have got rid of everything either in a trust or you got rid of everything before you died, and anything remaining was the transfer on death deed, like your home. So all they got to do is show your death certificate and you're dead. It transfers over. Now, there's different rules regarding ladybird deeds and the transfer on death deeds when they have to be filed and not, can they revocate and such. That's why it's important to seek an attorney's advice. What is best for your situation and what do you want to do when you're dead?
I and Bo, I'm not sure if you're in our probate help desk Facebook group. I think you are.
It just
You
joined.
Oh, great. You see me constantly recommending for personal representatives, executors, family members to get an attorney to talk through some of these issues. I've also seen scenarios where somebody thinks that they're all taken care of with their ladybird deed or their transfer on death deed, but they didn't record it in the proper sequence, and then they it doesn't apply.
For the Todd, that's fatal. For the ladybird, maybe not. But for the
Mhm.
Todd, yeah, you're done if they didn't file it. That shows you their intent. They didn't want you to have it.
Oh, that is absolutely true. Um, so you're talking a little bit about the will, and do you have any tips for families that you work with finding? So, for example, maybe someone in the family did a will, but they didn't file it. I know in Minnesota you can file it with the court right away, or attorneys will keep them, but up here some attorneys keep them a couple years, some will keep them 7 years, some don't keep them at all. What advice would you give to a family who think that their decedent had a will, but they're not really sure where should they look?
Well, usually safes under the bed. Now, most attorneys, like myself, we're going to make these documents stick out. We got ugly blue paper. It's hideous, but it catches your attention. Now, when we do it for our clients, we have it in a white little binder. It says Bowen Law Firm on it. So you know it's going to be legal documents. And then when they open it up, there's that ugly blue paper that sticks out right there. Everything's in order. There's going to be a zip drive in there with a box that says estate planning documents. So you can just stick it in the computer and get the PDFs. So we've made it a point to make sure this stuff sticks out. But if they didn't do that, unfortunately, you guys got to go through all the paperwork and just take the time to make for sure. And sometimes it sticks together. And
Mm.
sometimes they have more than one will. And it's last
Uh,
in time, last in right. So, but oddly enough, they could address some things in the will that came out here, but the will there they didn't. So maybe this one still controls and some not the other. And it can become a huge mess when people do this on their own.
so in a scenario like that where there are multiple wills, does the judge make the determination on which, if either are valid?
Well, in all reality, if the family can make an agreement into a family settlement, none,
Mm.
you're not going to need a judge. And
Hmm.
big picture, you don't want to. You want to keep that power with yourself. And with this mediation we've got that's been around for about 10 plus years, that has taken a lot of power. I mean, we can do things in mediation that judges really can't sometimes. So before we
Mm-hmm.
give that power up to a judge, it's always best to make sure that family sat down and understood, hey, we have something we can never get back. And it's usually
Absolutely.
best to get an agreement anyway. Let's keep the family working together. Let's not fight over stupid stuff.
100% agree. It's amazing how fast the inheritance can disappear once they start fighting.
Well, what's funny you say that because whoever the executor or executrix, because we're still a little bit sexist in the law, the executor is a male, executrix are females. Whoever has that role, they're going to use the estate funds to do this. So they basically have a piggy bank that ain't hurting them as much as everybody else. And they usually hire
Correct.
the most expensive attorneys and everything. What do they care? It's not best to fight across the board on these things. If we can get people to keep their level heads and work together, it's usually a win.
100% agreed. In fact, that was one of the things my attorney advised me on when I was personal representative. I was gearing up for some family dispute, and the attorney said it's going to cost you a lot of money if we go that route. Maybe you could just do an updated inventory and accounting, and we can settle this right away. And I'm like, I don't think so, but I did it, And my attorney
That's
was
a good
right.
attorney. He
My
put
attorney
your
was
needs
right.
above his own.
Yep. He in fact I still talk to him today. He's a mentor of mine now. He's
That's excellent.
fantastic.
We're supposed
Uh
to put your needs above our own, and he's right. Because it boiled down to, do you want to pay him or do you want to keep some more money for yourselves?
Absolutely. What so you were talking about scenarios where the family can reach an agreement if there is no will. So for example, in Minnesota, if there's no will, then you have to settle the estate according to state law.
Mhm.
If there is no will, can the family still reach an agreement that might not be in alignment with state law?
Well, some family may not have a say anymore when they would have if there was a will. So
Hmm.
normally here we're going to follow what statute says, and then
Right.
those people will have a say. But the amount that you would spend on a will, but we charge a base rate at $1,500 for the whole will package, including the signing ceremony, notaries, all that fun stuff. If you didn't do that, you're going to pay more than double or triple that going through the process because the things we got to skip because of it.
Yep.
It who wants to go find someone that signs on it, right? No, no one wants to find witnesses, and a lot of them are usually dead by that point. Who wants to do an error determination? Have to pay an ad litem to go and find this out and do a report? No, skip all this stuff. Keep your
Hmm.
money for your family like you want it to. Don't make extra work for these attorneys.
Absolutely. 100% agree. And I know here some families who don't have a will, they might end up I forget the number you just threw out there, but here it could be anywhere from 5 to 10 times more than what they would have paid if they just.
Especially if it goes into a deep end administration, easily it can liquidate the estate before they get anything out.
Yep.
Please take the time, do the work. And here's the thing, even worst case scenario, Texas recognizes a holographic will. This is not ideal, okay? But as long as it's wholly in the testator's handwriting and they can put everything to my wife, date, sign it, you don't need no witnesses. It's ripe for challenges. But in terms of
Mhm.
worst case scenarios, you still have options. Do the damn wheel. It costs you nothing but a few moments. And it still saves a lot of time in this process.
Absolutely. And a holographic will, can you define that for our listeners who aren't familiar?
Yes, sir. A holographic will is a will that is handwritten wholly by the person who's making it.
Mm-hmm.
It doesn't need witnesses. It doesn't need a notary. All
How,
states don't recognize them, but Texas is the one that does.
okay. Um, with the holographic will, do you tend to end up with more scenarios where people are challenging it or claiming it's fraudulent, or how do you defend that holographic will?
Well, you're going to have witnesses typically there when you sign that over to them.
Okay.
You're going to have people in the hospital or maybe at the scene,
Yep.
the emergency care workers and things like that. You can only get some supportive on it. Yes. But who wants to pay for all that?
Right.
Do it
Right.
right. You don't need to worry about that stuff. And this is what, if you're about to die, this isn't, let me get my will done real quick. No, that crap should have been done, man. Don't wait till
Absolutely.
last minute, but we have provisions that can help in the event that you did.
Absolutely.
What's funny is I use them in divorces a lot because they don't want
Mm-hmm.
their ex to get their portion of their separate property.
Mm-hmm.
And if you were to die before you get that divorce, well, sorry, unless you had a pre or post nuptial agreement, she wins.
Right.
Different rules, of course, if you had wills and also their step kids. But the point is, cover your butt. Get with an attorney. Make sure we got you covered.
Absolutely. And you were talking a little bit about the will and going to court. Well, you weren't ta we talked about going to court, but you were talking about the will and how much time and money you can save with the will. Um, do you have any other tips for avoiding probate? And I'm going to put this question into two categories because we get the people who want to do the smart thing and avoid probate while they're still alive, right? They're still alive. They want to do the proper planning so their family can avoid probate. I also get questions from families who find out they need probate and want to know if there's anything they can do to avoid it after it appears to be too late. So let I'll let you.
Yeah, after it's too late, SOL means a lot of things, but yeah, it's too late. It's too late. Typically, you have to be proactive, not reactive in this category. Oof. So, if people want to avoid probate, why? Why are you trying to avoid it? What is the point of it? You might be able to do it without a trust. Anyone goes online right now, TikTok, whatever, it's all about trust, trust, trust. I don't think most need them when why pay for it? They're expensive, at least they can be.
Hmm.
If you're worried about the house, that's only your big asset. Well, do a Todd, do a ladybird deed or something like that. Give everything away before you die, right? And if you did your beneficiary stuff correctly, this is the big B, not the normal word people think, but beneficiaries, it could be a B. If you didn't do that paperwork right, you may have to go to probate. But if you did it correctly, and anything with the big B is going to be controlled by the contract typically. So if your will said, I'm going to give everything to Bo, thank you very much. But your contract with the bank says the beneficiary goes to Rose, your lover. Guess what? Your lover's going to win, not Bo.
Right.
All right, which most of the time. So when you think of those things, you can prepare to avoid probate. There's nothing left to probate. You don't need the probate. Everything's gone.
Mm-hmm.
But there are definitely times you want to, though. See, a lot of creditors, well, you have to give them a notice, right? Within
Mm-hmm.
60 days, they don't come up. They're barred. Good way to get rid of debt. Well, again, you're dead, but then if that debt's not being paid, there's more access to go to loved ones.
Right.
So maybe you do, maybe you don't. That's why you speak with an attorney. Get the pros and cons. Or if you really want to prepare for it, you got to prepare for it. It's not something you can do after the fact.
Absolutely. And also, um, related to some of those disputes in the will, typically, does the will actually prevent a lot of those disputes, or do you still see some disputes even with the will?
If you got a butt head in the family, they're going to be a butt head even after they're gone, or you deal with them. This will ain't going to control or change that at all. If they feel like they've been robbed, they got the money to waste and spend, well, guess what? They're going to be a thorn in your side until they run out of money and get tired of paying for that attorney. Then eventually they end up settling usually. Rarely do
Mhm,
these things go to court. 98% of cases easily settle. I'm being pretty generous with the 2%.
mhm.
And it's not because people don't have good cases. It's because of the time and the cost.
Right,
No
right.
one wants to spend 100,000 to get 90 or 100,000. It
Mhm.
ain't worth it then. But in reality, what I've seen, no one really wins in a courtroom. You may win your point, but they don't win monetarily. They usually end up spending more than they get, and that's not a win.
Absolutely. How about the blended families? Do you have some tips for people who are doing planning and so for example, maybe there's a husband and then he has his wife and the wife has the stepkids, but the husband
Mm-hmm.
has kids from the original family. So a lot of people just assume that the wife is going to, get everything after the husband dies, but maybe the husband wants to leave some items for his kids,
Well, if that's the case,
biological
leaving
kids.
no will, at least in Texas, will work for him.
I'm sorry, say
Because
that again?
I said in Texas, if he doesn't do a will, they'll make sure that his biological kids are taken care of. So
Oh,
they
nice.
wouldn't leave everything to the wife. They actually would have ownership over property and things like that. She'd have a where she could stay for life on the
Hmm.
property and things, but it depends again if it was community separate. All that still plays a role, but no, she would not get the default then if he didn't do a will. Statute will make sure the biological children are taken care of.
Oh, excellent. Excellent.
But
What
what I
other?
found to avoid problems,
Hmm.
everyone sits down and goes to an attorney, get all this stuff written out, so there's no surprises. When
Hmm.
mom's expecting to be able to keep a house and all she gets a life estate, it can create some problems. And we don't want that. We want those families to stay together, especially
Right.
in these times. But they will fight over some of the dumbest things. I mean, pictures on the wall sometimes, much less money. People, I always tell my clients we need to be practical. They don't like hearing it. Quit being principled. It's not about
Hmm.
principles in the sense that we're right and wrong. Yes, I get it. But to enforce your ideas of principles on someone else in a courtroom, even if I come out and we're one, yay, you're going to spend more, you're going to get. And that
Hmm.
doesn't make a happy client. So in a courtroom, while I want highly principled clients, I want them to be reasonable and practical in a courtroom, realizing it's usually not worth it. And when they see that, I get happier clients. But the usually ones that go all the distance, if we win, they're still not happy. You got to
Right.
be practical here. We're not going to be able to prove our way to them. We're not going to teach them anything. Wrong venue.
Yeah. And in a situation like that, if you are representing the executor or executrix, and there's a dispute within the family, do you, as the attorney representing the executor or the estate, do you mediate that for them, or do you encourage them to get their own, the other family members to get their own counsel? How do you navigate that?
I have found it is best when both have attorneys, as
Mm-hmm.
I don't want to be explaining it all, and I can't to the other side anyway. There's a bias there. I can't represent them. Now, mediation everywhere I go anymore, at least every court but one judge in Galveston requires mediation before you'll ever see them. And that's been
Oh.
kind of the trend of all the counties I've been in Texas. I haven't hit
Hmm.
all 254, but I've been in a whole lot of them, and every one of them pretty much require mediation prior to seeing a judge. Fix this poop on your own, at least try to before you bring it to our table. And they're right. This is their
Hmm.
problem. They should try to fix it on their own first. And inevitably in mediation, if you have a good mediator, they're going to point out the flaws in your arguments and theirs and hope the two of them see. And if people embrace the concept of mediation, the concept of mediation is, what can I live with? Not
Right.
what do you want? What can I live with? And that means everyone should be getting what's important to them, and everything else kind of falls to the side. And actually, a good mediation is when everyone leaves unhappy. It's a damn
Mhm.
job, I tell you. But yeah, a good one is when everyone leaves unhappy, but they got an agreement.
So when if a family chooses to go through mediation, then are they in the mediation process? Are they represented by their attorney, or do they go through
You're
mediation
not
themselves?
required to be, but usually you do have attorneys with you, so we'll be there as well. And you prepare for mediation. You know
Hmm.
your BATNA and your WATNA, your best alternative to the
Yep.
negotiated agreement, your worst alternative, right? So you know between here's what we should get no matter what. We ain't going to accept this. But there's
Right.
also, again, a benefit cost analysis. If fighting for this is going to cost you more than it's worth, no, sometimes the jerks win because it ain't worth fighting for. That's why companies settle in some of these cases that are ridiculous, because it's easier to pay them $5,000 to go away than spend 100 to fight it, to prove I'm
Yeah.
right. They deserve nothing.
Wow. So one of the tips I'm taking away from this is if you find yourself either as the executor or a family member who has a dispute, if you're in Texas, it sounds like you have to go through mediation unless you can resolve it on your own. But
Correct.
even for our
Well, mediation
listeners,
is a way to resolve it on your own.
right, right. Oh, true. Correct.
But what's good about mediation, once you've got a valid MSA, immediate settlement agreement,
Hmm.
outside of a bloody gun to your head or blatant fraud, right?
Hmm.
That is going to be turned into an agreement and you're going to move on. They can challenge it all they like. The chances of it being overturned is next to none. You finally got a pedestal you can stand on. I'm getting through this damn thing. You can now see the light in the tunnel.
Sure.
It takes away
In
buyer's remorse.
in Texas, what happens if one of the parties will not agree to mediation?
Well, the court requires it. And if you
Yeah.
don't go, they'll reach an impasse. And then you can go to the hearing and you'll be getting some attorney's fees. And the court is not going to be happy about that. And they'll tell you, here's the date and time in the media you're going to be visiting.
Hmm.
Yeah, you don't do that. In fact, I encourage them to go ahead and do that and see how it works out.
Yeah, and unfortunately, once they find out, it might be too late, right? Some of these things, it's very costly to go back and try to undo them or redo them.
Yeah. They say
Wow.
you can't take the stink out of the jury box, right? That's what they say.
Yes. Um, so one more topic I'd like to address. How about executors who become so in Minnesota, if you're named in the will, you're the executor, and then when you file for probate, you become the personal representative. What what do you see as one of the big mistakes or challenges that those executors often make?
Not doing the accountings just because you get 15 months doesn't mean you shouldn't just go ahead and submit it before. Communication will save you headaches and attorneys. Just communicate. Whether you gave it to them again last week, they asked for an update, give it to them again.
Hmm.
All right. Show that you're above reproach. Make it so they can't come in and go, hey, they shouldn't have this job. They can do that at any point, but the accounting, if they haven't done it by the 15 months, we got a good argument they ain't doing what they're supposed to. And that
Hmm.
isn't the time to start trying to scrambling for 15 months worth of work and distributions to account for it to get it out in a detailed report to cover your butt.
Right.
You cannot assume the family is your friends and such. At that point, no, they're not. And you owe them a duty and they're expecting it. They're going to want a hell of a lot more than you ever wanted to give. That's the
Hmm.
reality. And guess what, Buttercup? No, you're not going to get paid for it. The
Right.
majority don't. Congratulations on being the good child or the dependable one. That's what we win for doing it. And if you're an attorney, yeah, you always get stuck with those cases. They'll never
Mm.
call you for anything other than a case just like this. That's what you get for being dependable. Accept your role, get it done, and just keep taking the high road. Don't let them hurt you. They're doing nothing. They have all the time to think about it while you're working and doing everything else you would normally do on top of that task. I get it's difficult, but it's not difficult to create a joint email where you can just send all the stuff out to the group at once. If they're an heir, a beneficiary of some sort, just create one, keep them all abreast at the same time. I would make clear you don't do phone calls individually. We're going to talk as a group that avoids doing the same thing 20 times.
As I mentioned, when I was personal representative, I ran into this issue and I learned my lesson. Fortunately, we did not have to go to mediation or court. We worked it out before
Good.
before that happened. Um, and now as a real estate agent working with families going through probate, one of the things I will do for my families is I will record all of the conversations that I have with the personal representative so that they can share it with the entire family.
Nice.
So if we get multiple offers, I go through them, record it. If we want to make a price adjustment, we record that. Everything we do, we record it. And I have had family members come up to me and tell me how that extra communication allowed them to all be on the same page.
That's an
And
excellent tip.
yeah,
Did you tell them you're recording?
yes, absolutely. In fact, what I would do is I would sometimes, depending on what the meeting was, I might just do an independent presentation, record it, and then send it to the personal representative and encourage him or her to send it off to the rest of the family. And then other times I'll record with them on as long as they give me permission. But yeah, I don't ever secretly record them.
Well, I don't know what the rules are in your state, but in Texas, we're a one-party state. And that means you
Mm-hmm.
can record without permission and without consent.
Oh,
They can
wow.
even say, don't record me. No one cares. We're going to record you. We can lie. Are you recording me? No. And I can, and I will, and I get to. And I guess, sure, I can still use it to protect myself or show that you didn't tell the truth.
Yeah. So far, I have not had anybody ask me to not record. But they don't say much during the video anyway. It's usually me just going through everything that they're dealing with. So
But in Texas, they don't have to. So as the executor or executrix, record all the communications.
yeah,
That way you can show versus tell. Anytime you're in
yeah.
the courtroom, that's what wins. Showing, not this. This doesn't win cases because that's what they're going to do. No one knows. This shuts
Hmm.
this up.
Absolutely.
But I
Uh,
encourage my clients to do belt and suspenders. The belt's recording the phone call, right? The
mhm.
suspenders is followed up with that email to the joint with everybody else. Hey, I had a conversation with so and so. It should have been a group, but it wasn't. Here's what we discussed. Here's what we said. Bam, everyone's on the same page. Save the recording for your own butt, and you're good. And keep moving along.
It's really interesting because for the families who follow that advice, they might not even realize how much time and money they're saving. Um, it's I'm laughing because I deal with people who are hesitant to go through probate without an attorney. And a tip like that alone would more than cover what you're spending on attorney fees in some cases. You
I'm a
know.
little biased myself in that. I absolutely agree. What you get for our experience and training alone, much less how we know the judges. A good
Hmm.
attorney knows the judge. I'm sorry, a good attorney knows the law. A great attorney knows the judge. And I don't
Yep.
mean they're my buddies. I don't golf with these guys or gals, but we know how to present it in a manner that we can get in and get out. They're not going to be scrutinizing our stuff. We've done it 1,000 times. They know the name. We know what to give them. Keep checking the boxes, nodding their head, and we're in and out.
Yep. That was the experience I had with my attorney. In fact, I asked for a referral from another attorney that didn't handle probate. And he said, you got to go with this guy. He knows the law, he knows the county, he knows the judges, he knows what they want, and he costs a little bit more than everybody else, but you are going to avoid a lot of problems. And I would have paid him twice. When we were done, I would have paid him twice what he charged me. I mean, it was so true.
That's a Google review waiting to be written. He will love it too. You
Oh,
got to hook him up with
absolutely.
Google.
That's a great suggestion. So we talked about some of the problems the executors face, some of the timelines, and you mentioned in Texas, I think you said a probate case with the will typically can be about 6 to 9 months, and without it's can be up to 15 months to 2 years. Did you say?
Or longer, unfortunately. Yes, sir. Unfortunately, hey, you always have an open timeline if you don't have a will and how it's going to go, especially if it becomes a dependent administration. And this is where you hear the nightmares. Rarely do you have these when people did a will and no one's contesting it, which is the overwhelming majority.
Right.
They're in out 6 to 9 months, which sounds like a long time, but unfortunately, in my world, that's blazing speed. I mean, we're on par with geologists, right?
Right.
That's about as quick as it's ever going to get in my world.
Absolutely. And Bo, we also talked about living wills, trusts, family disputes, some challenges for executors. Is there any other parting advice that you would like to leave our audience today?
Just one more thing regarding the ability to record and showing versus telling. I
Mm,
have found when clients do as I asked, and we're keeping Murphy at bay. Murphy's law. If it can go wrong, it will. And but I'll have that and just show it. It shuts down the arguments. Instead of having to pay for a hearing, it's going to cost you $5,000, $10,000 or more. It got done for less than $100 of your time by going here. No, and it's done. It's fantastic. The number one thing I've seen people miss Even I did. It was a client that brought it to my attention years ago. Is this thing? A smartwatch, much less the Apple Watch. This is one of the best recorders that you can get. It has voice memos just like your cell phone and everything else. But your cell phone's in your pocket. You're trying to be smooth and keep it down. You don't need to do any of that stuff. Just flick up, start recording, and enjoy your conversation in Texas. And then you're going to have what you need. But please also follow up with a text real quick and go, hey, thanks for talking to me today as we discussed. Or like you said, or even if you didn't agree, we agreed on this, but we didn't agree on this. I have no doubt that we're going to work this out together. It gives you an opportunity to show you're not the problem. Take those opportunities to help me help you when I'm in court.
Right. Absolutely. Bo, this has been very, very helpful. For families who need assistance, where would you like them to get in touch with you, or how would you like them to get in touch with you?
You can find us online at www.bowen, Bowenlf, as in law firm.com. That's BOWENLF.com. You can also call us at 713-574-7777. That number again is 713-574-7777. And I have a phrase, I like it a lot, and it's when the going gets tough, the tough get Bowen.
There, there you go. Well, you had another phrase on your website that I really liked, and it was Bo knows law.
That's correct. I really wanted Bo Jackson. He's not allowed to say anything Bo knows.
Yeah.
But
Yep.
yes, sir, Bo knows law. I have one for Christmas too, because we are the Santas of law firms. Is I'll put a bow on your legal case.
Oh, very nice. Very
I have
nice.
t-shirts. But make sure I get your sizes up. I'll get you some Bowen swag. And it's been a really good time talking to you today. This has been more of like a fun conversation than a podcast.